Okay. Assalamualaikum, madam. My name is MEGAT FARHAN IZZAT, and I'll be talking about my article, which is the indivisibility meaning of good faith. This article started with the brief explanation on National Land Code 1965. The law governing the land matters in Malaysia is National Land Code 1965. Then the NLC provides the torrent system of the title registration. Under a torrent system, the registration is everything, and the state guarantee an indivisible title to anyone who is registered on the registered title. As reflected in the section 340, clause 1 of the National Land Code 1965, regarding the indivisibility of title, it was provided under the section 340 of the NLC. Section 340 of NLC deals with the indivisibility of a registered title to an interest in the land and in land, and the term indivisible, though used in section 340 of the NLC, is not defined clearly. So by a judge-made decision, this term has been judicially defined as immune from attack by adverse claim to the land or interest in respect of which he is registered. Our Malaysian laws have applied the doctrine of definitive indivisibility, whereby only the title registered by a bona fide third-party purchaser is immune from any other attack from the outside, and such third party must prove that he possesses and obtains such title or interest under good faith, as per the case of T. Sivam. So, the case that was reviewed in the article was T. Sivam anak lelaki Tara Malingam versus Public Bank Berhad. In this case, the Federal Court in Malaysia has the opportunity to revisit the meaning of good faith in section 340 of clause 3 of the NLC. This case is about a dispute between parties in regards of competing claims on a same piece of land. The original registered owner of the land and a chargee bank who actually was a subsequent holder of the interest of the land were both affected by a fraud that has been done by a third party. So the decision of the court for this case was made by three courts, which is the High Court, Court of Appeal, and the Federal Court. So High Court has set aside the charge on the ground that the chargee bank was an immediate acquirer or holder of interest in the land and therefore could not claim protection under the proviso to section 340 clause 3 of the NLC. As for the Court of Appeal, the court decided to reverse the decision of the High Court. The court held that the chargee bank was subsequent and not an immediate holder or acquirer of interest in the land in good faith, and for valuable consideration, therefore has a protection under the proviso to section 340 clause 3 of the NLC. Lastly, the Court of Appeal granted the leave to appeal to the deceased. The Federal Court agreed with the decision of the Court of Appeal that the chargee bank was a subsequent holder of interest in the land, and the key to the determination of this appeal centers on the meaning of good faith in the context of section 340 clause 3 of the NLC. So the Federal Court laid down the elements required to prove the existence of good faith. Absence of fraud, deceit, or honesty that not simply represents good faith. It requires acting honestly and reasonably or fairly, which then includes taking ordinary precautions that ought to be taken. It is not enough for a purchaser to merely show any absence of fraud, deceit, or dishonesty. Element of carelessness and negligence negates good faith. In allowing the deceased appeal, reversing the decision of the Court of Appeal, the Federal Court set aside the charge and held that the chargee bank did not require the interest in the land in good faith on the grounds that the knowledge of the same common solicitor who handled the transfer for the son and then the loan transaction for the chargee bank, that there was a serious dispute as to the ownership of the land, and of the allegation that the son, the customer of the chargee bank, obtained title to the land by fraud. The aforesaid knowledge of the solicitor was acquired in the earlier, which is the first transaction, namely the transfer of the land purposely for the deceased to the son, is regarded and treated by law as a knowledge of the chargee bank. So in the light of the fraud allegation, which the chargee bank is regarded as knowing by imputation, there was a real necessity for the charging bank to conduct further investigative work in the face of suspicious and uncertain circumstances under which the transaction of the transfer of the land. The charging bank failed to make further inquiries before creating the charge and disbursing the loan. The federal court clarified that the general rule is that the knowledge of the solicitor is regarded by law as the knowledge of the client, except where the solicitor is complicit in fraud. In conclusion, accordingly, when acquiring title to or interest in land, an acquirer or title to or interest in land should act honestly and take ordinary precautions that ought to be taken in doing so. He should be careful not to act carelessly and negligently. Further, the acquirer should conduct further investigative work and make further inquiries when the circumstances are such that he is or should be put on inquiry. Keeping in mind that the knowledge of a solicitor is regarded by law as the knowledge of the client, by imputation, it is prudent to engage a solicitor, a law firm who is not privy to any previous dealings with land. That's it from me, madam.
Greetings to Dr. Amalina. My name is Shanthini Joselene, and for my assignment 2, the article that I've chosen is titled Landowners Beware, A Tale of Indefeasibility by Alif Benjamin Suhaimi and Phoebe Loy Yenwei. Let us look into the legal principles of indefeasibility of title. Since independence, Malaysia have been adopting the torrents of registration in relation to the land law. In this system, it means that a person's interest and right over a piece of land must be registered in order for them to enjoy the legal protection. This is a very important process for ownership of land, as an owner's title over a piece of land is indefeasible, or in a simpler definition, not subject to being lost, annulled, or overturned once it is registered. There are two types of indefeasibility, which is immediate indefeasibility and deferred indefeasibility. Immediate indefeasibility means that an immediate purchaser of title or interest will have indefeasible title, notwithstanding that the title or interest was obtained pursuant to vitiating circumstances, whereas deferred indefeasibility is where subsequent purchaser of land acquired by means of fraud or forgery, where they found to be acting in good faith and have purchased the land for valuable consideration, would be afforded an indefeasible title to the land. Let us look into the sections from the National Land Code 1965 that talks about the indefeasibility of title. Those sections are section 340, subsection 1, 2, and 3 of the National Land Code. By clearly reading section 340, subsection 1 of the National Land Code, I can summarize that any title or interest of any person whom is registered as the proprietor of the land shall own the property lawfully or shall be indefeasible, subject to the following provision of the section. Moving on, although section 341 provides indefeasibility of title to the lawful registered proprietor, there are certain circumstances in which a title shall not be indefeasible, as stated in section 340, subsection 2 of the National Land Code. Some of the circumstances in which title shall not be indefeasible is when registration of the title is obtained by forgery or void instruments, in any case of fraud or misrepresentation or unlawful accusation. Moving on. Although the indefeasibility of title is a right that cannot be challenged or attacked, section 340 subsection 3 of the National Land Code states that the title can be made defeasible by reason of any circumstances stated in subsection 2. From my understanding, the title made defeasible is where the title of an immediate purchaser can be opened in principle to revision or annulment if tainted by one or more of the vitiating circumstances stated in subsection 2. Last but not least, under section 340 subsection 3, there is a concluding proviso stated that provided that nothing in this subsection shall affect any title or interest acquired by any purchaser in good faith and for valuable consideration, or by any reason or body claiming through or under such a purchaser. I would like to highlight the meaning of good faith and valuable consideration under the concluding proviso in subsection 3, which is where good faith is the act of being honest and fair, whereas valuable consideration is a benefit conferred or a detriment incurred by a party in exchange for another's promise. Let us look into one of the most famous cases that comes to our mind when it comes to the indivisibility of title, which is the case of Adona Properties Sendirian Berhad against Bunsem Bunyani at Sun Yok Eng 2001 from the 1 Malayan Journal 241. Madam Bunsem Bunyani was the respondent. She was the owner of a piece of land which was sold and transferred to Adona Properties, whereas Adona Properties was the appellant. The facts of the case was Madam Bunyani claimed that her signature was forged by the vendor and was sold and transferred the land to Adona Properties. A claim was filed in the High Court for Madam Bunyani to be restored as the registered owner of the land. The High Court dismissed the claim, whereas the Court of Appeal reversed the High Court's decision and restored to Madam Bunyani her rights in the land. Adona Properties appealed to the Federal Court, and the Court of Appeal's decision was reversed to Adona Properties. In this case, it was held that the provision in Section 340, subsection 3 of the National Land Code excludes all purchases in good faith and for valuable consideration from the substantive provision of Section 340, subsection 3A and B of the National Land Code. In other words, Adona Properties' title over the land enjoys immediate indivisibility as it had purchased Madam Bunyani's land in good faith and valuable consideration. This was despite the fact that her signature on the instrument transferred had been forged by the vendor. So the issue that arose from this case was whether the appellant, a bona fide purchaser for valuable consideration, without notice acquired an indivisible title to the land by virtue of the Section 340, subsection 3 of the National Land Code. From the issue, I would like to highlight the meaning or the definition of a bona fide purchaser. A bona fide purchaser is a person who has purchased any asset, including real estate, for a verified value, but who is innocent from knowing any facts that would create doubt about their seller's right to have sold the asset in good faith. As an overall evaluation of this case on Adona Properties against Madam Bunsem Bunyani, I can evaluate based on my readings that this case decision has been unpopular to say the least, and it actually drew much criticism from many legal academia as being clearly wrong. From my point of view, I feel that Madam Bunyani's right and justice she deserved as a legal and beneficial owner of the land was not reserved. After a few years, the Federal Court, comprising a panel of 5 judges, actually held that the case of Adona Properties was wrongly decided. They held that the concluding proviso under Section 240, subsection 3 of the National Land Code is directed only to Section 240, subsection 3 alone and not the earlier subsections. That's all from me, presenting my part for this assignment 2 of Article N, Decided Case Review. Thank you.
Good morning to the level lecturer and also all my teammates. My name is Husna, and today I'm going to present my part about land law, which is indivisibility of title. So before we go into details, I am going to explain what does it mean by indivisibility. So what does indivisibility means? As the author wrote, it is a measure of conclusiveness given to the estate or interest in emanated land or registration of the appropriate dwelling in statutory form. However, there are conditions in order to obtain indivisible title, such as system of title or interest registration. So basically, if you are under the title of indivisibility, it is quite hard for you to revoke your land because your land is not possible to revoke, except for under few circumstances. I'm going to explain this later. So moving on, I'm going to move on with the next slide. So The author also explained the history and the concept behind indivisibility. So the basis of the foreign system is that is obtained from the execution of the statutory instrument, but from its registration. So this will affect the party in whose prove that registration, and it will secure indivisibility title or interest in the state land. So as a concept and the basis of foreign system, that is why we have indivisibility. So an important concept as stated in National Land Code is that this means that once an interest such as ownership is registered in the title deed, it is a good against the whole world. So the state guarantees interest. So if you are under the title of indivisibility, it protects and also guarantees your interest and also your title onto land. So the registered title or real property determines who has a property interest of ownership of such property, as mentioned in section 340. So, for example, if you wanted to buy a land and you wanted it to be unrevocable, so you have to deal with the owner of the land in order to gain that title, as mentioned under section 340. So, however, indivisibility does not imply in fraud, misrepresentation, forgery, because indivisibility is something that you cannot be revoked, you cannot be taken. The land is permanent. So, if it happens between fraud, misrepresentation, and forgery, is another title. So, I'm going to explain about section 40, clause 1. It mentioned that the title or interest of any person or body for the time being registered as proprietors of any land in whose name any lease, charge of easement is for the time being registered shall subject to the other provision is the same section be invisible. So whenever a person has the power over a land, it is revoked. So that is why fraud and misrepresentation forgery does not apply in this, because the land is unrevoked. So you cannot actually susukati tarik the land because it is under title of indivisible. So, so I'm going to move on to the next point. So the author also explained between two type of indivisibility, which is immediate and deferred. And I'm going to explain two of them, and I'm going to explain what makes it different. So immediate invisibility occurs or explains as when a purchaser's name is registered in the title deed. So invisibility may be lost only if that timelessly before title is transferred to bona fide purchaser for a value without notice of the vitiating factor. So bona fide defines as good value or good faith. So immediate invisibility means immediate ownership. I mean, immediate land ownership. So it only happens when a purchaser's name is registered in the title deed, and you can lose invisibility if you are actually not a bona fide or and it has to transfer to someone with a good value. So so moreover, stating in section 42 of the Federated Malaysian State Code, they also introduced different indivisibility. So what does it mean? So as the slide presented, the inability of an efficient or void instrument to give title. So the indivisibility is actually tarik balik or revoke the title of indivisibility because it is an inefficient or void instrument to give title. So maybe he or the person or the party has involved in misrepresentation of fraud. So that is why we apply different indivisibility. So he is not capable to actually have the title. So if competing claims between the original owner and a subsequent purchaser in a good faith and for valid bill constitution, the latter would be entitled to the property of ownership. So I'm going to explain. Okay, let's look at an example. Okay, so for example, party A acquires the title to the property by fraud. Soon, party A transfer the property to party B. However, B's title to the property is protected and cannot be set aside if B acquires in good faith and for valuable consideration. This also protects successors in the title and interest of party B. So as this example share is like, if a party A acquires either by fraud, they can actually transfer it to party B, but it requires good faith and valuable consideration. So that is why this is how the court or the court actually determines who actually have the power to the land. So last but not least, I'm going to explain the case that is written in the article. So we are looking at the case of Kamal Zaman bin Omar, and others. So this case is about fraud case and it's all about indivisibility. So the fact of the case summarized when a company was by a fraud transfer registered as a proprietor of land belonging to co-proprietors who were outstated from the registering dealing. So what happened was the federal court also held that the title company became an immediate purchaser when it was registered as proprietor and wanted this title acquired was tainted with forgery and fraud. It was divisible. So as I mentioned earlier, indivisible does not include in fraud and misrepresentation because of this case. So that is why the interest was held to be indivisible because it was acquired in good faith and for valuable consideration. So the federal court also declared the doctrine of deferred indivisibility in Malaysia, and the highlight of Section 340, Clause 3 of the National Land Code is applicable only to a subsequent bona fide purchaser for valuable consideration. So as this case explains about a fraud case, basically Kamrul Zaman or the party, was involved in a fraud case, and the federal court has determined, who has bona fide, who has the power to actually make this land indivisible. So hence the explanation of this whole case. So I think that's all for today. So I'm going to conclude. I'm going to conclude my point by saying that indivisible of title is actually very, very vital in this country. And for me as a human being and for me as a future lawyer, I am going to focus more on this title in order, for future planning. So I think that's it for today. And thank you so much for listening.
Assalamualaikum and selamat sejahtera. I bid to my respectful lecturer. I am SYAZWANI Abdullah, and today I will be explaining and giving the summary of the case and the article that I've chosen for this assignment. Let's get started. As you can see, the case and the article that I've decided and chosen is Rajabani Anak Perempuan Maya Pacetia and Eng Beng Development Sendirian Berhad and others. Let me first give the summary of this case, where the appellant was the registered proprietor owner of a piece of land, and the plaintiff name had been replaced with the name of the second respondent and subsequently with the name of the first respondent in the registered document of title. And the original issue document of title was in the possession of the plaintiff at all material times. In addition to lodge a police report, the plaintiff also entered a private caveat on the land and proceeded to file a suit in the High Court against the first and second defendants. And according to the second defendant, the land was purchased from an imposter named Rajamani for a consideration of Rm 1.2 million ringgit. And the third respondent, a partner in the fourth respondent, was an advocate and solicitor who acted for Rajamani in the sale and transfer of the plaintiff's land to the second defendant. The continuation, the fifth and sixth respondents were the land authorities responsible for all transactions in respect of the land, while the seventh respondent was a legal assistant who acted for the second defendant. The Judicial Commissioner dismissed the plaintiff's claim against all the defendants except for the second defendant. And now we'll start with the tale of bona fide purchases and indivisibility of title, which the definition. In 2010, the Federal Court in Tan Ying Hong and Tan Sian San and others held that the proviso in Section 340 of the National Land Code conferred deferred indivisibility on subsequent bona fide purchases for value. And deferred indivisibility means that subsequent purchases of land acquired by means of fraud or forgery, where they found to be acting in good faith and have purchased the land for valuable consideration, would be afforded an indivisible title to the land. This is notwithstanding any innocent original owner of the land being deprived of the same. This deferred indivisibility was to protect the titles of subsequent bona fide purchases from being defeated due to the fraud and or forgery involved in prior transaction. So this is a departure from general principle taken from the article. which, however, the Court of Appeal in Rajamani Anak Perempuan Maya Pachutia and Eng Beng Development Senjam Berhad and others controversially departed from the principle above when it held that a title which is tainted by fraud or illegality is incapable of conferring a valid title to the subsequent bona fide purchaser. Thankfully, the Federal Court in January 2019 has since reversed the Court of Appeal decision in Rajamani and affirmed the position as per Tan Ying Hong and Tan Sian San above. The Court of Appeal further held that mere fact that the first defendant had purchased the land in good faith and for valuable consideration did not confer indivisibility to its title if such title was otherwise void at inception. And interestingly, the Court of Appeal held that in situation of competing interests between an innocent original landowner and a subsequent bona fide purchaser, the scales of justice must tilt in favor of the innocent landowner. Moving on, Federal Court weighed in. The Federal Court reversed the Court of Appeal decision above and affirmed the original doctrine of deferred indivisibility. Notably, the Federal Court upheld the High Court's finding that a land title will be void if and only if the land registry had in blatant breach of its duty under the NLC wrongfully registered any land in the registered document of title and issued the replacement issue document of title in the name of the third party. And applying to the principle to the facts of Rajamani, the court held that the titles issued after IDT1 were validly issued by the land registry and that IDT2 was in fact issued in the name of the original landowner. Therefore, while the document of title used for the subsequent transaction to the bona fide purchaser was found to be divisible by reason of fraud, and the doctrine of deferred indivisibility was applicable, this meant that the subsequent purchaser in this instance obtained indivisible title to the land by virtue of being a bona fide purchaser for value of the same. And Richard Malanjum CJ, as he then was, recognized that the concept of indivisibility of the torrent system favors a subsequent bona fide purchaser for value over the original registered proprietor. And the Federal Court also made clear that the law has to be applied as is, despite the perceived injustice to the original proprietor as an unfortunate loser. To address this injustice, Richard Malanjum CJ instead called for the relevant authorities to consider the need for assurance funds to compensate innocent original proprietors who have been the victim of fraud and forgery. In my point of view, what I understand and what I have summarized from this article, I think that the validity of the originating title issued by the land registry should be a non-starter, because the purpose of the doctrine of deferred indivisibility is supposed to protect subsequent bona fide purchasers regardless of the validity of the originating title of land in question. And the language of the Proviso to Section 340 subsection 3 of the NLC does not state any exceptions applicable to the doctrine of deferred indivisibility. Furthermore, the emphasis of conclusiveness of the register of titles in a torrent system, as encapsulated in Section 89 of the NLC, supports the notion that the validity of the preceding title to a subsequent bona fide transaction should not be an issue to be considered by courts. That is all from me. Thank you.